Hello and welcome to this Hangout on Air brought to you by the Shriver Center. My name is Amanda Moore. I'm the Director of Online Content and Communities at the Shriver Center. Our guest today is Michael Hollander. Michael's a staff attorney at Community Legal Services in Philadelphia. Hi, Michael.
Hi.
How are things in Philadelphia?
Good. A little bit snowy, but we're recovering.
Okay. So it's not really always sunny in Philadelphia, I guess.
It always is sunny in Philadelphia.
Well, it's icy in Tennessee today, so it's all sorts of winter excitement. So I want to welcome everyone who has joined us today. And before we jump into talking with Michael about his article, I want to address a few housekeeping matters. The purpose of these Hangouts is for us to hear from you, for us to have a conversation, and for you to get to know a leader in the legal services and equal justice community a little bit better. So to do that, we have a couple of ways where we can interact while this is going on. If you are watching us through Google+, through the Hangout, you'll see in the upper right of your screen there is a little icon, it's a little grid. If you click on that, you'll see a blue icon that says Q&A. So if you open that, it's a question and answer app within the Hangout feature, and you can send us questions. If you want to go ahead and give that a try, go ahead. You won't appear on screen or anything like that. It's just a chance for us to get your questions to us while we are doing this. You can go ahead, you can send us your name and where you're watching just to get that channel of communication open. The second way you may be watching us today is live streaming through the Shriver Center's YouTube channel. If you're doing that, you can still send us questions, send us your stories, anecdotes, whatever during this chat. You can do that through Twitter. So just tweet to us at Shriver Center, and we will get those questions so we can ask Michael what you want to know while he's here with us. All right, now let's turn to our guest, Michael Hollander, and his article. It's called Finishing What You Started, Collecting on Judgments for Low-Wage Workers. Now, this article will be published by the Shriver Center very soon, and we're very excited about that. It's the first of our new type of articles called Clearinghouse articles. And those of you who are long-term Clearinghouse review readers may be very excited to know that you can read this for free. Clearinghouse Review has been a subscription-based publication for quite some time now, almost 20 years. But we are now entering a new dawn of publishing, and so we'll be publishing articles on a rolling basis, and those are available for free. You simply go to the Shriver Center's website, which is povertylaw.org, register on the site, and you can access those articles for free, as well as the Clearinghouse Review archive, which just on our site alone is 25 years of Clearinghouse Review articles, so it's a great resource for your practice. We will have a new platform launching on our website as well. It's called Clearinghouse Community, and that's where you'll be able to see all this great new content that will be available to you for free. I see we have some people who are watching. I want to welcome Amy Carpenter and Greg in Lafayette, Louisiana, and Eileen says hi from Pittsburgh. So we've got some folks tuning in from all over. I'm going to see if we have any tweets yet. Not yet. I'm sure we will soon. Okay, so let's turn now to Michael's article. So I want you, if you could, briefly tell us what the scenario is that we're talking about today, because I think a lot of us, especially if we come from a consumer law background, we hear the term collections and we think someone's coming after our clients, but that's not what you're talking about.
That's right. So for lawyers or for legal aid lawyers who practice in the employment arena, we're often working in a space that's different from the rest of our colleagues in the legal aid world. So as opposed to consumer lawyers, bankruptcy lawyers, housing lawyers, people who are doing that kind of work where they're defending their clients against claims by creditors, we're actually in the opposite space. We're often in the position of becoming creditors. So our clients may have, in a typical situation, they've worked at an employer for a period of time. They weren't paid in some way what's often called wage theft. So they might not have been paid the minimum wage. They might not have been paid overtime. They may not have been paid at all for a period of days, weeks, or months. And we go and we file a lawsuit and we gain a judgment. And when we gain a judgment, suddenly our client becomes a creditor, and the employer becomes the debtor. So the typical scenario where the consumer civil legal aid lawyer might have a client who's a debtor, and they have a creditor going after them, we're reversing that situation. So we're going after an employer as a creditor. The common thread that I would say that I see between these two scenarios, because I know that other legal aid lawyers get worried when they see us pushing for different tools for creditors to use, because they worry that it's going to be used against their clients, is our clients, just like the consumer legal aid lawyers, are clients who are at a disadvantage as compared to the person on the other side of the table. The person on the other side of the table is usually a much better funded and much better organized employer in my case, and in the case of a consumer lawyer, maybe a bank or another agency that might hold debt for somebody.
Right, I think that's a great point to make. Sometimes our clients are creditors. I used to run into this when I was practicing against some companies, people who'd had damage from coal companies, and the coal companies would file bankrupt, and then suddenly I had these low-income clients who were creditors. So it's an interesting turn of the tables. So let's say you do move forward with a lawsuit. Your client wins. Suddenly you are the creditor, and your employer's not standing there ready to hand over a check. What are some things, practical tips that you could do to make sure your client gets that judgment in hand?
Yeah, that's a great question. So one of the things that I would say up front is that there's so many different tools that are out there to use, and each situation is going to require different tool or set of tools to use. So for example, if your judgment is against a company that has a physical presence, so a restaurant, a corner store, a hair salon, somebody that actually has a physical site where they conduct business on a regular basis, that's going to change the types of things you do as compared to, say, a construction contractor who just goes from construction site to construction site, or a cleaning company that doesn't have any physical presence anywhere. They just have contracts with different employers. So to tackle the first scenario where we're talking about someone who has a physical site, there are things that are not in the legal process, so you can take direct action of some sort. You can maybe protest in front of the store or in front of the restaurant. You can also do things like try to garnish bank accounts that you would assume that any legitimate business that has a storefront of some sort would have. You can also, in a more extreme scenario, you could file for a sheriff's sale of the contents of the restaurant or the store or whatever it would be. And the good thing about something like that is a restaurant does not want to have its assets sold. So even if you could go through with the sheriff's sale, you could sell their tables and their chairs and their liquor and their food equipment and whatever else you could get your hands on through a sheriff's sale. That would essentially destroy the business. So to the extent that the business is viable still, they're going to want to pay that judgment off before you actually go through with the sheriff's sale. So even just the threat of being able to do something like a sheriff's sale, the ability to schedule something like a sheriff's sale will put you in a better position to collect or at least negotiate with the employer. In the other situation where you have an employer like a janitorial company that doesn't actually have a physical location, they're a fly-by-night company, they work, they have cleaning contracts maybe with different department stores or restaurants or office buildings, they can be a lot harder to go after, and you have to get more creative with what you're going to do. So you can certainly try to garnish bank accounts to the extent that you know that bank accounts exist, or you think you might be able to find some. That's certainly a possibility. But you might want to get more creative. You might want to say, okay, well, I don't know where this person's bank account is, or they might not have one because I get paid in cash all the time, and I'm pretty sure they're getting paid in cash. But I could go to, as a lawyer, I could potentially garnish, say, the restaurant where they're cleaning. So I could say, let's say they're cleaning, Tim's restaurant. You could go to Tim's restaurant and you can say, look, you're supposed to pay this cleaning company $500 next week. Instead, I have this court paperwork that says you have to pay that to me instead of Tim, instead of the cleaning company. And then Tim's restaurant is going to be legally obligated to send the money to your client. So you might be able to find different things like accounts receivable that that business might have, even if it doesn't have any physical assets or a physical location to go after.
So what are some ways that you actually find out about these bank accounts? I know one point you make in your article is that the collections process really begins the moment your client walks through the door. You don't even have to wait for filing a suit because you can start this research. So what are some of the things that you do to look to see, is this actually something we're going to be able to collect on?
Right. So the first thing obviously is to have a conversation with your client to really get a good understanding of what type of a business is this. How are you paid? Are you paid by check or cash? Have you had checks bounce on you in the past? Does this person have regular business? Do they have a storefront? If they're a construction contractor or a building cleaner or something like that, do they have regular clients that they're dealing with on a everyday basis? And you're trying to establish one in your head, are there sources of money where I'm going to be able to collect, or at least accounts receivable? But you're also trying to get an idea of, are there other deep pockets that I should be suing? Are there joint employers? And this is just standard thing that we might do in employment practice. So the cleaning company, if it only really has one contract and is with one restaurant, might be a business that you could actually go after both the cleaning company and the place where they're cleaning, since the cleaning company is probably just a pass-through to get money to workers, and they've created some sort of subcontracting relationship just to avoid liability like this and other tax liability. So that's one thing you could do to start. It's also worth getting your head around the size of the business. A really small business is far more likely to be judgment-proof versus a 10-plus person company. If you have more than 10 people working for your company, you're probably going to have some of the accoutrements of a bigger company, like a regular bank account, like accounts receivable that are able to be gone after. And then I do a lot of web searching. So just going on Google and searching for the company. If you can't find any online presence for that company except for sort of the automatic databases like Yellow Pages and things like that, then you should start to wonder whether this company is making itself intentionally hard to find. Because even the smallest legitimate businesses have at least a presence on Yelp or on Google+, or they have a small website, even if it's not a very good one. If you're unable to find any of these things, it's a little bit worrisome for the collections process. There's also lots of helpful things that are in the public domain or available through commercial databases. So you can go to, for example, LexisNexis has a public business records searching tool where you can go and you could type a business in, or you could type an individual's name in, and it will give you a lot of information back about that business or that person. So you could see, for example, if they own any property. You could see for how long the business has been registered in your state. You can see if they've been sued in the past. You can do the same thing by going to state court or federal court websites to see if this person's been sued in the past. Being sued in the past can be a mixed blessing. If someone's sued many, many times, and you see that in every instance where they're sued, they just default, and then there's never a satisfaction of judgment filed, then you can be pretty sure the same thing's going to happen in your case. And you can be pretty sure that the employer knows that they're judgment-proof and has just chosen not to defend any lawsuits because they don't care. On the other hand, if there's a few judgments against the person, especially if you see that some of them have been satisfied, that can help you with a couple of things. It can help you to find where to serve the employer so you can actually start your lawsuit in the first place. It might give you hints as to where assets exist, because you might see, for example, that a paperwork was filed with the court to garnish either a bank account and then the judgment was marked as satisfied, or to garnish some sort of other company that might be viable accounts receivable, and then you see the judgment being satisfied. So as the lawyer who is going to be doing collections in the future, you get an idea of where potential sources of money for your client would be in the event of a judgment.
Those are really great tips. I want to, first of all, say hi to Dorinda from Minneapolis Legal Aid and remind our viewers that we welcome your questions. Also, if you have any stories, any tips that you have found are really good that we should all know about for trying to collect these judgments for our clients, please let us know. You can tweet us at Shriver Center, or if you're watching through the Google Plus Hangout on air, open that Q&A app and send us a question that way. One thing that you have been involved in, Michael, for a few years, is this emerging collections tool called a wage lien. And so not all of our viewers may be familiar with this. Can you tell us what that is?
Sure, absolutely. So one of the things that I discuss in my article is that to the extent possible, coming to an agreement with an employer for that employer to pay you is the best way to collect on your judgment. So from the very outset, I'm not saying that you should seek a settlement over other courses of action if the settlement's not going to be in your client's favor. But if you can get a settlement agreement, that's going to be very helpful to you. Because it'll mean that you have a willing employer who's interested in stepping in and paying your client. You don't have to go through the process of finding their assets and the risk of going to court and losing and all those different types of things. A lot of advocates have found that there's a tool called a mechanics lien, and this is sort of a roundabout answer, so I apologize. But there's a tool called a mechanics lien, which many advocates probably know about. It's available in essentially every state, although in different forms. Where if a construction worker works on the alteration of a building, you can file a lien you can file a lien against that building. So the owner of the building is now liable to pay you, and the idea is that the owner of the building can then go after the contractor who didn't pay your client because they have maybe the deep pockets, they have more resources to go after this individual with the higher priced lawyer, and they're also just in the lowest cost position to essentially get your client paid. They can withhold future funds from this person. They have all the contact information and so on. What advocates have found is that threatening or filing a mechanics lien often leads to very quick settlement and payment for your client. So to get back to the original question, there's a tool out there called wage liens, and it's been around for a long time. Although in very few states, and only in Wisconsin had it been updated as of 3 years ago, the wage lien statute. And what a wage lien is the same idea as a mechanics lien, but it's generalized to any worker at all. So what that would mean is that any worker who works on a property, before they go to court and actually file for a judgment, could file immediately for a lien against the property of the employer, who they were ostensibly working for, as well as the property on the site where they were working. So if you're a janitor, for example, and you work for a janitorial company that's subcontracting to a large big box store, often you'd have trouble filing a lawsuit, or you'd have a very litigious issue as to whether the big box store was actually an employer of yours. So that could be a difficult risk that you go into the lawsuit with. If you have a wage lien, you could immediately go and you could file a lien against all the assets of the janitorial company, which might be none. But you could also file against the assets of that specific store location that you worked at, which would mean that suddenly this big box store is on the hook to pay your client. And what they're going to do is they're going to go to the cleaning contractor and say, look, you need to pay this individual or you're going to lose your contract with us. So it's a quick way for us to be able to get money in the hands of our clients, and often at in very favorable position. We started working on the wage lien issue maybe 3 years ago in this larger group, and we've written model legislation. We've written some white papers about how wage liens are, or why wage liens are good tools and why they're necessary. The National Employment Law Project did an excellent report called, I believe it was called Hollow Victories. It came out last year. And Hollow Victories talks specifically about why wage liens are so good and how they actually improve. They look at a case study between Wisconsin and California and show how vastly different the outcomes are for people in Wisconsin where wage liens exist versus California in certain scenarios. So we've done a lot of work to create space to work on wage liens in a legislative manner, and there's, I think, 6 states now that have been working on wage liens, and Maryland passed a wage lien law just about 2 years ago. Pretty quickly, actually. They really got something to the legislator very fast. They've gotten regs together, and they're already starting to work on filing some of the early wage liens. So it's been a really excellent tool. It's one that I think every state should look at in terms of improving their wage enforcement and their wage judgment collection. And it's one that we're really trying to support people around the country with doing.
Well, that's great. That sounds like a really useful tool. I want to ask you, you said it's something you've been working on. I know that you have a monthly judgment collections conference call, that a group of advocates get together every month to strategize these things. Could you tell our viewers more about that, and if they want to get involved, what they could do?
Absolutely. So yeah, I don't want to take credit for doing this myself. I've more facilitated a lot of conversations around getting wage liens done, but I have not done most of the heavy lifting. So 4 or 5 years ago, a number of us started getting together for monthly phone calls through the Low Wage Workers Legal Network run by Michael Dale. But we've sort of split off and made our own group for judgment collections. But we have a monthly call. It's on the second Wednesday of every month at noon Eastern Time. And every month consists of about 15 minutes of updates on legislative advocacy that have been going on around the country regarding wage liens usually, and then about a 30-minute training by some expert around the country on a different topic relating to judgment collections. And these have run the gamut from very basic primers on what is a garnishment, what is a levy, how do you do a sheriff's sale, what are very basic techniques for judgment collection, to more in-depth conversations about various aspects of bankruptcy, which many people who are doing judgment collections ultimately end up having a debtor or an employer go into bankruptcy. Or conversations, the one next month, for example, is about evaluating an employer's assets when you're in a settlement posture, but they're threatening bankruptcy or insolvency, and they're saying, look, we need to settle for a much lower amount than you're asking for because we can't afford to pay this. And the call is all about how do you evaluate that employer's assets to see if they're telling the truth or if they're just trying to get away with something. So if you would like to be involved in the calls, we'd love to have you. They're, again, every second Wednesday of the month at 12 noon Eastern Time. And Amanda, I think, is going to give out my email address later in the call, and it will be on the paper. But you can just email me, and I'll include you in the mailing list, and you'll get notice of the calls every month.
That's great. Thank you for sharing that. This sounds like a really useful call. We have a couple of questions that have come in. One is more of just a practical matter. Amy asks if the webinar is also available on YouTube. Yes, Amy, it's live streaming right now on the Shriver Center's YouTube channel, which I believe is called Poverty Law. And it will also be archived there and on our website, and we'll send out an email to everyone who registered for this Hangout with the link to that, so you can watch it again later if you missed the first part, or if you have a colleague who would like to watch. The second question is a little more substantive. It comes from Eileen, and Eileen asks, does the judgment collection process differ between profit corporations and nonprofits?
As far as I know, and my knowledge is mostly based on Pennsylvania law because that's where I practice. Although I've had a lot of conversations with people in different states, the answer should be no. If you have a judgment against a company, whether it's a for-profit or a non-profit, the laws should essentially be the same. That you have essentially these two tools. One that I call, I think they're called different things in different states, but in Pennsylvania they're called levy and garnishment. And basically what they are attaching the assets of the employer or the defendant, whoever that defendant is. And one deals with attaching their assets if they're still held by the defendant. That's when you would have something like a sheriff's sale. And another is attaching the assets when they're in the hands of a third party. So that would be something like garnishing a bank account or garnishing accounts receivable. But none of the laws that I have seen have any provisions in there that say that this acts differently if the company is a for-profit or a non-profit.
All right.
One thing that I should mention is that if your defendant is an individual, which in employment cases, especially in these smaller cases, happens a lot, there will be some exceptions to what you're allowed to levy or garnish. So for example, if I went to a restaurant, I could levy everything and have a sheriff's sale of anything in that restaurant. If I went to your home because you were an individually named defendant, I probably, at least in Pennsylvania, I couldn't garnish your clothes, I couldn't garnish your Bible, I couldn't garnish some other personal things that have been written into the statute as exceptions. Also, if I went to your bank account, there's a certain amount of money that statutorily can be held back by the bank to pay for their fees, but also I couldn't garnish things like Social Security money that's being deposited into your account.
Right. Eileen asks a follow-up. She wanted to clarify that what she meant is whether it's harder to find those assets when you're dealing with a nonprofit than a for-profit company.
I think really, so the bigger difference comes in not whether someone's a nonprofit or a for-profit. The bigger difference comes in when you have a fly-by-night business versus a legitimate established business. Any legitimate established business, first of all, will hopefully just pay when there's a judgment against them. To the extent that they're not paying, it's just a question of, do they keep their money in bank accounts, and do they have those bank accounts obscured in some way? If you're dealing with a fly-by-night contractor or cleaner, they might have bank accounts, but they're in the name of a spouse or a relative, or they keep all their money in cash, or they keep their money in a bank account that has one branch and it's in Delaware, so it's very difficult to find. So I don't think that there's a difference that I've seen between nonprofits and for-profits in terms of finding money. It's more between legitimate and less legitimate businesses.
All right, thank you for those questions, Eileen. And I want to encourage our other viewers, where our time is actually running very short. So if you have a question, go ahead and send that in now. Or if you have a tip that you would like to share, ask Michael if he has worked with that. Please go ahead and send us that too through the Q&A app or through Twitter at Shriver Center. I want to move past your article just a little bit and tell our viewers that all of the strategies that you mentioned so far, you go into more detail on those strategies in the article. So I encourage everyone to read that once we send them the link to it. But moving beyond the article to your broader practice at Community Legal Services there in Philadelphia, what are some other things that you work on besides just collecting on wage cases?
Yeah, so the employment practice, so Community Legal Services is not an LSC-funded organization, so we, I guess we have no restrictions, I would say, in terms of the types of cases that we work on. And our employment unit works on a pretty broad variety of cases. So we work on almost any type of case that touches employment, except for ones where there's definitely a private lawyer who will handle it. But our two biggest areas are, one, wage and hour cases, which the collections would fall under, and two are criminal records cases where the criminal records are a barrier to employment. So we, for example, help people get expungements and pardons to clear their criminal record. We do advocacy and file lawsuits against employers when individuals have been denied jobs because of their criminal record, when that record's old or minor or remote from the type of job they're applying for. And we filed lawsuits against background check companies who are providing background checks that are not accurate, at least, or 100% accurate. So we do a lot of that work. You know, we handle discrimination cases, and we help people with severance agreements and all sorts of other things. We also do lobbying on a variety of topics, including unemployment compensation. So it's a pretty wide practice. I feel like a jack of all trades sometimes.
That's not a bad thing. In fact, I was going to say our next article coming up after Michael's is by Peggy Stevenson with the Records Clearance Project at San Jose State, and she's writing about expungements. And in fact, some of Michael's work came up in the context of that article, where he developed some software that automatically fills out some forms for expungement petitions, right?
That's right, yeah. So it's a tool that we use in Pennsylvania for helping with expungements. So I'm excited to be in 2 articles in a row.
That's right. Well, we're glad to have you too. So our time has actually come to an end. If you have questions that we did not get to today, I want to encourage you to do a couple of things. First, read Michael's article, which will give you a lot more details about these great practical tips on collecting judgments. As I said, we will send you the link to that article, as well as a link to the recording of this Hangout. Expect that within the next few days. Everyone who registered for today's event will get that, so even people who weren't able to tune in live with us today. You can also get in touch with Michael directly. As he said, he's willing to let me announce his email address, which is mhollander, so it's MHOLLANDER, at CLSPHILA.org. So you can get in touch with him about anything from the Hangout today or about the monthly calls that he talked about earlier. So I want to thank all our viewers for joining us today, and I invite you to join us for next month's Hangout. Next month I'll be talking with Dan Lesser. He's the Director of Economic Justice at the Shriver Center, and he'll be talking with us about this year's Poverty Scorecard, which is when we take a look back at last year and grade every member of Congress on how they voted on legislation that affects people living in poverty. So that should be pretty interesting. It will be on Monday, March 16th at the same time as this Hangout. It'll be 1 o'clock Eastern and 12 o'clock Central Time. So thank you again, Michael, for joining us today.
Thank you very much. I enjoyed it.
And to the rest of you, thanks, and stay warm until we see you next month. Bye-bye.
Bye.